what I found quite groundbreaking is that you can add timestamps to these videos on YouTube. So the timestamp really is that it divides the lecture into chapters or sort of parts. So you put in, so let's say you start speaking about the WHO 10 minutes into the lecture. So you put 10 minutes as the marker, and then from, let's say, 10 to 15 minutes, you speak out the WHO, and then you move to pandemics at the 15th minute. So you put all this information down, and then it comes as a sequential order when the video is published. So it
that's great.
makes research work very easy.
Yeah.
Let me just reach out to Professor and find out. So he'll join in a couple of moments.
Sure.
It's confirmed. He's here. So
Hello, sir.
Yes.
Yes.
Am I audible?
Sir.
Good morning.
Hi. Everybody's there. Let me see. Hello, Kristina. Hi, Ankit. Hi, Abhinav.
Hi, sir.
How are you doing today?
I'm doing very well, Kristina. Thank you for your time, by the way.
Oh, it's my pleasure.
We apologize that this comes in a time when students have the kind of the final week and they're a little bit anxious with exams. In Jindal, we start a bit earlier, but we have a good audience. I see almost everybody, which is good. Students are listening to us. That's excellent. Okay. I wanted just to finish a mail to the authors of the book, which will come out of this series, by the way. So, Kristina, you will be also invited to contribute a book chapter after your lecture.
Great.
No pressure. But we agree with Routledge to publish a book, an edited volume, consisting of, well, basically using the topic reimagination of international legal order.
Excellent.
And I've just sent maybe Ankit will see that in his book. We just sent some guidance. We will talk about this later after your class. So go ahead. So the format is 90 minutes, but this includes question and answer sessions. So you can start now, and I will moderate the question session after you finish. Thank you very much, Kristina. My big pleasure and honor to invite you to the Tyndall Society of International Law and the Center of the Study of United Nations in Jindal Global University. We have students who have studied the law and practice of the United Nations system over the last 3 months, focusing on the principal organs, the International Court of Justice, the General Assembly, the Security Council, ECOSOC, and how do they reflect the international constitution and international law in time of challenges, in time of pandemics and climate change and populism rising in some countries. And the purpose of the series is how does international law and international organizations generally reflect on those challenges? Do they continue in the same traditional way they've been doing business as usual, or do they adapt, and how successfully they adapt, if they do adapt, to the challenges of the 21st century? So that's the format and the purpose of the series. So please go ahead. We are extremely happy to have such an honorable speaker with us today. Thank you for your time. Hopefully one day in the future we'll bring you physically into our campus in India and have a face-to-face opportunity to listen to you. But at the moment we still cannot do that, so it will be an online session. Thank you once again, Kristina, and your time starts now.
Great. Well, thank you so much for having me. I'm delighted to be speaking with you this morning and very much look forward to having the chance to discuss my remarks and to answer any questions that you may have at the end. And I do hope that at some point we have a chance to meet and to talk about these issues in person. So in my talk today, I want to start by exploring what exactly we mean when we talk about international organizations. It's rather striking that even today, at least some aspects of that question remain rather murky. So the recent edition of a European textbook on international organizations pronounced the task of defining international organizations as impossible. Now, it is true that there are a number of borderline cases, and I'll talk about some of those a little bit later, but we can nevertheless make sense of a category of what I want to call traditional international organizations. And in my lecture today, as we're thinking about reimagining international law, international organizations, I want to address both sources of resilience and sources of fragility in international organizations as a mode of cooperation among governments. So, as actors on the international scene, international organizations developed somewhat gradually, and some of their key features are still in the process of emerging. So let me briefly touch on some of the milestones. The early 20th century saw Sir Eric Drummond as the first Secretary General of the League of Nations crystallize the concept of an international civil service. In constructing the League Secretariat, Drummond rejected a plan under which the League's Secretary General would preside over a cabinet composed of 9 separate national secretaries, one from each nation represented on the Council of the League, who would be assisted by their own staffs recruited from their respective countries. Instead, Drummond organized the Secretariat into sections by function, right? So there was a legal section, an economic section, an information section, and sought to create a genuinely international officialdom. Subsequently adopted regulations required all League officials to discharge their functions and to regulate their conduct with the interests of the League alone in view, and prohibited them from seeking or receiving instructions from any government or any other authority external to the Secretariat of the League of Nations. So these two features, an international composition and responsibility to the organization rather than to national governments, came to define the international civil service. In 1949, in its reparation for injuries advisory opinion, the International Court of Justice affirmed that the United Nations had independent legal personality separate from that of its member states, and as a result, had its own rights and duties under international law. This meant that the United Nations could make international law. It could enter into treaties. It could violate international law. And when the United Nations itself was the victim of a breach of international law, it could make a claim for reparations against member states and non-member states alike. In the decades that followed, the International Law Commission played a key role in further specifying some of international organizations' rights and duties, in particular, their rights with respect to treaties and their duties with respect to responsibility for violations of international law. Some important questions about the place of international organizations in the international legal system remain unsettled, and I'll come back to this as I elaborate on some of the sources of international organizations' fragility. But first, I want to talk a bit more about exactly what we mean when we're talking about international organizations. It's quite striking and maybe surprising that the very definition of international organizations remains somewhat elusive. So let me take a few minutes to canvass some of the definitions that have been put forward. So the 1969 Vienna Convention on the Law of Treaties and the 1986 Vienna Convention on the Law of International Organizations Treaties both rather unhelpfully define the term international organization as intergovernmental organization. This definition does give us a sense of who the members are, right? We're talking about organizations that are at least primarily composed of governments rather than private actors. We're not talking about multinational corporations or non-governmental organizations that operate globally. In 2011, the International Law Commission adopted draft articles on the responsibility of international organizations, and those articles defined an international organization as, and here I'm quoting, an international organization that is established by a treaty or other instrument governed by international law. So that's the first factor. Second, possessing its own international legal personality. And third, international organizations may include as members, in addition to states, other entities. So this is a more fleshed out definition than we saw before, but this second feature, right, possessing its own international legal personality, raises all kinds of questions that the International Law Commission didn't answer. The draft articles don't tell us how to evaluate whether an organization has international legal personality. The reparation for injuries opinion that I mentioned earlier provides some limited guidance on this question. So in evaluating whether the United Nations has separate legal personality, the court looked to three factors. It looked to the purposes assigned to the United Nations, and those were, and here I'm quoting, to achieve these ends, the attribution of international legal personality is indispensable. Second, the court looked to the organization's structure. The court observed that the Charter and the United Nations is not merely a, quote, center for harmonizing the actions of nations in the attainment of those common ends, for the Charter has equipped that center with organs and has given it special tasks. Moreover, the Charter has defined the position of the members in relation to the organization by setting out specific obligations that the members owe the United Nations, such as the obligation to accept and carry out the decisions of the Security Council. And third, the court cited the United Nations practice, and in particular, the conclusion of conventions or treaties to which the organization is a party. So we have these three factors that are present in the case of the United Nations, but nowhere did the court tell us which of these might be necessary, which might be sufficient to establish that a given organization has legal personality. There's one more three-part test that I want to offer, and this is the one that is found in a well-known and highly regarded treatise by Henry Schermers and Niels Blocher that gives a slightly different three-part definition. Their treatise defines international organizations as forms of cooperation that are, number one, founded on an international agreement. Second, have at least one organ with a will of its own. And third, established under international law. So let me pause again on this second factor, the organ with a distinct will of its own. So what does that mean, right? The idea here is we're looking for something indicating that the organization is something more than, or at a minimum different from, the sum of its parts. And there are two main ways that a distinct will might be demonstrated. It might be an organ that is made up of representatives of states that can take certain decisions by majority or supermajority vote. So having studied the United Nations, you might think of the General Assembly and its capacity to adopt recommendations or to approve a budget without requiring the agreement of all participating states. The second way you might have a distinct will is an autonomous secretariat, an international civil service along the lines that Drummond first created at the League of Nations. So I think if we take these various definitions, we can come up with a longer, more comprehensive list that defines what I'll call a traditional international organization, right? I think these are really the criteria that we are looking for. So we're looking for entities that are made up of states and perhaps also of other international organizations. The key feature here, and the reason why private actors as members are likely to remain marginal, is that only actors with their own international legal personality can take on international obligations in connection with a particular organization. So our members are going to be states and perhaps also international organizations. We're looking for an entity that's established by a treaty. And here I want to pick up on the idea from the reparations opinion that for the organization to have separate legal personality, it needs to have some structure, right? There needs to be a there. Treaties are the means that states use to establish such structures. This requirement also offers an implicit contrast to organizations that are created under national law, right? By definition, an organization under national law is going to be subordinate to the legal and regulatory authority of one member state. I think we need to look for both elements of a distinct will that I mentioned earlier, both an international civil service whose autonomy is protected and an intergovernmental organ that can take some decisions that don't require unanimity or consensus, right? Majority or supermajority or even qualified majority voting. And then finally, we need the absence of any indication that states are actively resisting creating something that looks like an international organization. And so here the example that I want to offer up is the Organization for Security and Cooperation in Europe, the OSCE. So the OSCE emerged from the Conference on Security and Cooperation in Europe, which was a diplomatic conference series convened in various capitals on an ad hoc basis. And it stood out at the time as one of the few venues in which the United States, the Soviet Union, and Western Europe engaged one another during the Cold War. The CSCE's best known output is the Helsinki Final Act, which is a classic example of an influential but not legally binding document that articulated Cold War consensus positions on human rights. In the early 1990s, the CSCE's participating states established various structures, including institutions and field operations, but they consistently avoided adopting any kind of document that defined the CSCE as a unitary institution. In 1994, the CSCE was renamed the OSCE, right? The Organization for Security and Cooperation in Europe. But the decision document announcing that change also stated that the name change, quote, alters neither the character of the CSCE commitments nor the status of the CSCE and its institutions. So again, that kind of language in a decision adopted by governments is a rejection of the idea that the participating states are creating something that looks like a traditional international organizations. So having set out, right, what it is that this universe of entity has in common, I want to step back and look at some of the trends that we have seen during the second half of the 20th century and the first 2 decades of the 21st. So if you were to look at the population of traditional international organizations during this time period, right, roughly 3/4 of a century, what we would see is that the population of traditional international organizations grew quite dramatically before starting to level off at approximately 300 around the turn of the century. And we might explain that leveling off in population in a variety of ways, right? So first, we might say that, well, we would expect trends in the population of international organizations to roughly track trends in the population of states. The more states you have, the more organizations they create, right? Aside from the universal organizations that make up the UN system and are particularly well known, there are many regional and sub-regional organizations throughout the world. And indeed, the trend line in the growth of international organizations roughly tracks the trend line in the number of states in the world. So as the number of states has leveled off, so too has the number of international organizations. Second, and alternatively, we might say, look, this leveling off is exactly what you would expect in a mature or a saturated international system. Once all of the major bases for cooperation are covered through a mix of general and more specific organizations, states are going to cooperate by directing new work to existing organizations instead of creating brand new organizations. But there has also been, and especially over the last 20 years, evidence of a more conscious and more deliberate rejection of the traditional IO model. And these rejections have taken a variety of forms. So sometimes the alternatives reflected a preference for a private sector mindset and a private sector way of doing things. The Global Fund to fight AIDS, tuberculosis, and malaria was established outside the UN system as a foundation under Swiss law rather than by treaty. There was, of course, and perhaps most notoriously, US President George W. Bush's preference for coalitions of the willing, which manifested most consequentially with the 2003 invasion of Iraq. There was a new focus on transnational networks, direct cooperation among national bureaucracies without an intervening organization. And I want to highlight here that from a US perspective, the most vocal proponent of transnational networks, Anne-Marie Slaughter, had a high-level position at the State Department under the Obama administration. So if we're looking at this trend, and again, this is quite a US-centered perspective, it's not one that is associated, excuse me, with either just the political right or just the political left. And looking at these trends, some scholars suggested that in the 21st century, the world had moved into a post-institutionalist era, had become much more interested in informal or soft forms of cooperation. And indeed, developments in 2016, in particular, the Brexit referendum, the election of Donald Trump in the United States, seem to confirm this characterization of a post-institutional world. Now, I disagree. I don't think we're living in a post-institutional era. In my view, developments over the past 20 years have demonstrated the durability of the traditional IO model. So where do I see support for that model? Anecdotally, in recent years, there are examples of new organizations that are being created in the traditional model, either in the first instance or as an evolution from a type of organization that specifically rejected the traditional model in its original incarnation. So some prominent examples include organizations where China is playing a lead role. So I'm thinking here of the Asian Infrastructure Investment Bank and the Shanghai Cooperation Organization. In terms of organizations that aspire to universal membership, we might mention the International Criminal Court and the International Renewable Energy Agency, which was established in 2011. There are also examples of organizations that are making incremental moves in the direction of traditional international organizations. So take, for example, the Global Fund, which I had mentioned earlier. In recent years, the Global Fund has entered into a headquarters agreement with Switzerland. The International Labor Organization's Administrative Tribunal has acquired jurisdiction over disputes between the Global Fund and its employees, and a multilateral treaty protecting the Global Fund's privileges and immunities has entered into force. The General Counsel of the Global Fund recently co-authored an article in which he explained that these steps in combination reflect, and here again I'm quoting, an evolution of the Global Fund into an international organization. In 2012, there were serious discussions about transforming the UN Environment Program from a subsidiary body of the General Assembly into a separate organization that would be a new specialized agency of the UN. Ultimately, the UN Environment Program remained within the United Nations, but there was a decision made to replace its 58-member governing council with the UN Environment Assembly, a plenary body with universal participation by UN member states, exactly the kind of organ that is associated with traditional international organizations. And finally, I want to mention the International Organization for Migration. So IOM has qualified as a traditional international organization for some time already, since 1989. But in 2016, IOM formally became a related agency of the UN. So if there's a possible step beyond becoming a traditional international organization, it's becoming integrated into the UN system. So this raises the question, what explains the persistent attraction of the traditional IO model? And I want to argue here that it's a need to appeal to multiple external audiences, right? To actors other than those who are directly involved in establishing the organization. And I'm thinking in particular about non-member states, about other international organizations, and about private actors, including potential staff and employees of the organization. For these external audiences, it may matter quite a bit whether a particular institution is a traditional IO or not. So let me give, again, some examples about how each of these external audiences can matter. In a world that is increasingly crowded with international organizations, it can be quite useful for institutions to obtain observer status at other international organizations in order to exchange information and to coordinate policies. And it's much easier for entities that are recognizable as traditional international organizations to do this. It's not necessarily flat out impossible for other entities, but it's surely more complicated when the organization's status is in doubt. Along similar lines, organizations that are seeking to expand their membership will have an easier time doing so if they can persuade potential member states that the institution conforms to a familiar model. So a lawyer closely involved in the negotiations establishing the Asian Infrastructure Investment Bank explained it this way. She wrote, starting with something workable, known and respected, would offer something reliable to governments, financial markets, potential recipients, and contractors. Finally, institutions that are readily recognizable as traditional international organizations will have an easier time securing protections for their employees. And that factor may in turn influence the willingness of individuals to work for a particular institution. So going back to the example I mentioned earlier of the Organization for Security and Cooperation in Europe, it continues to lack a foundational treaty and some of the indicia of traditional international organizations. And the OSCE has struggled to ensure that its officials enjoy legal protections when they are traveling throughout the OSCE region on OSCE business. And the significance of these external audiences suggest that international governance may have more in common with property law than with contract law. So let me explain what I mean by that statement. In both civil law and common law countries, contract law gives parties very wide latitude to craft their agreements as they see fit. By contrast, property law tends to insist on a limited universe of building blocks for transactions. And a powerful explanation for this difference is that property transactions are relevant to a number of external actors who aren't parties to that particular transaction, right? A property transaction has consequences for potential future owners. They have consequences for other individuals who might be tempted to trespass or to steal. And property law, in short, keeps things simple because it needs to communicate to a broad audience. By contrast, contracts can be much more complicated and idiosyncratic because they typically impose obligations only on the parties to that particular contract. Now, when it comes to designing international institutions, contract law may initially seem like the more apt comparison, right? The participating states get together, they decide what kind of entity, formal, informal, traditional, non-standard, best suits their needs, the extent of their commitments, their willingness to pay for an international civil service. But what I'm arguing is that, in fact, this looks more like property in the sense that there is a need to engage with all these various external actors, and that need to engage with these external actors creates an incentive for international institutions to conform to a broadly recognized, standardized type, that of a traditional international organization. And international institutions that are idiosyncratic or informal or otherwise unusual and fail to conform to this type are going to face costs and complications when they're engaging with any entity outside of the direct participants. These types of non-standard institutions are going to remain persistently vulnerable to challenges that are going to hamper their efficacy. And all of these factors contribute to some pressure for standardization, and I think explain the durability of the traditional model. So if that's an account of the durability of the traditional model, I now want to turn to the flip side and address some sources of fragility of the traditional model. So there are two in particular that I want to discuss. One is funding. So international organizations of all kinds are becoming increasingly reliant on voluntary contributions to fund their activities. The World Health Organization is a rather extreme case. Less than 1/5 of its budget currently comes from assessed contributions. The rest comes from voluntary contributions, mostly from states, but also from private actors. And those voluntary contributions are almost always earmarked or conditioned in a way that limits the ways that they can be used to particular narrow projects. And this increasing reliance on voluntary contributions is a particular risk for two kinds of work that international organizations do. So first, to the extent that voluntary contributions are used to fund normative work, right? Things like setting standards or identifying best practices, the risk is that instead of reflecting the organization's best judgment and an international perspective, the work is going to reflect the donor's preferences to, say, protect powerful domestic industries. Or even if the normative output doesn't actually reflect the donor's preferences, they might be perceived to do so, and for that reason, be less influential and less effective. Second, some international organizations are tasked with evaluating the conduct of member states and publicly criticizing those states when they fall short. The concern here is that organizations that rely on voluntary contributions will tamp down their criticism to avoid losing voluntary contributions, or again, that they might be perceived to do so. And strikingly, a number of offices and programs whose work actually or potentially involves such evaluation and criticism rely quite heavily on voluntary contributions. The Office of the UN High Commissioner for Human Rights had a $180 million budget in 2019. Voluntary contributions furnished about 2/3 of this amount. Now, the secretariats of international organizations are alert to these risks, and they have devised a variety of strategies to manage them. But for the most part, these strategies are informal. Few of them are written down and publicly available. So the underlying concern here is that international organizations will lose their ability to speak with a uniquely credible voice in the international community, a voice that simultaneously reflects the interests of all and none of the participating member states. A separate source of fragility is international organizations' surprising but widespread reluctance to expressly acknowledge their place in the international legal system, and more specifically, to their reluctance to acknowledge that as members of the international community with separate legal personality, they're bound by customary international law. This in particular is the unsettled question to which I had referred earlier. The combination of silence about obligations under customary international law and the very loud and explicit invocations of immunity under national law that international organizations have made has resulted in a persistent unease that international organizations actually are, or are striving to be, above the law. This concern has been especially prominent in recent high-profile cases concerning the immunity of international organizations, where individuals who were harmed by an organization's acts or omissions pursued legal action in national courts only to encounter defenses based on immunity. Two recent examples in US courts include claims against the United Nations for the role that UN peacekeepers played in bringing cholera to Haiti in the wake of the 2010 earthquake, and the lawsuit against the International Finance Corporation in connection with harms caused to fishermen in India by a power plant that was funded by the International Finance Corporation. In both cases, US courts ultimately supported the defendant organization's immunities. The plaintiffs who sued the IFC won their case before the Supreme Court in 2019, but earlier this summer, a subsequent decision by a lower court shut the door that the Supreme Court had opened. I worry that these organizations have won these individual battles, but that they may be losing the war, because each successful invocation of immunity heightens the concern that international organizations are above the law. In that way, each invocation of immunity threatens to erode support not just for those individual organizations, but for international organizations as a category. So there's a relationship here to the first source of fragility that I mentioned. The less broad-based support there is for international organizations, the harder it's going to be to improve the funding picture that I just described. So where does this leave us? I've made a descriptive argument for why the traditional model of international organizations remains attractive. The challenge is to make sure that the traditional model also remains attractive as a normative matter, that the multilateral character of international organizations isn't a mere facade, and that international organizations themselves don't undermine the international legal system by claiming to hold a place outside of it. In other words, as there is pressure to converge on the traditional model, we need to make sure that this model is worth converging towards. Thank you very much.
Thank you so much, Professor. It was a illuminating talk, and I do have a couple of reflections which I would like to share based on the lecture. Professor Popovski.
Yes, I also have a couple of comments to share. Shall I go first, Ankit? Yeah. Well, thank you, Kristina. It was wonderful. Really, your scope of covering the traditional international organizations, but also how they do shift over time as to accommodate, I will say, the dynamic and changing international legal order is interesting and also controversial. As you pointed out, the attraction of the traditional international organization is there, but also at some point they discover the difficulties, as you said, the challenges to find funding. If it is voluntary contribution, it might not work very well. But if they do accept voluntary contribution, then they can lose the traditional way they used to act, exactly because they were very much more politically supported at the time. There is also another controversy here, and WHO is a good example of being at the same time a political organ of governments representing ministries of health and others in the same way, but also being in itself an expert-based body where a lot of experts, no matter whether they come from Europe, Australia, America, Africa, they also need to work as experts together. And it applies also to other organizations. Let's take the Atomic Energy Agency, the Organization for Prohibition of Chemical Weapons. They have very much expertise in a particular field, but at the same time, their work as experts could be affected by some political challenges existing at the moment. And they're both victims of being political organs, but they're also victims of being expert-based which do not exactly reflect the original, probably, mission and original purpose. And a good example, I used to work for the United Nations University in Tokyo over 10 years in the past. And in my view, the biggest challenge there was exactly how to bring together the huge voluntary contribution of Japan. Almost 90% of the existence of United Nations University in Tokyo depends on the Japanese very generous contribution to the organization. And similarly, it has to remain a United Nations organ following all the rules and regulations of the United Nations system, which includes the geographical distribution of all the posts, the gender balance. So to follow the UN rules and regulations, and being sponsored 90% by a Japanese government, which obviously expect the UNU to act very much in accordance with, let's say, generally the Japanese foreign policy and foreign priorities, was a difficult bridge to make. As you said very well, Kristina, that you either sacrifice the voluntary contribution, you act as a UN, you don't care about Japan, you reaffirm Article 101 and say no government can tell us anything, we are United Nations, we don't care about governments. And then you need to take 90% of your budget from a single government. So how do you square that conflict? And it has been I will say, even a kind of original identity problem of the United Nations University itself. I remember we ended up by saying that United Nations University is a university without students, whereas the United Nations Institute for Training and Research is an institute without research. Kind of even we went into very much identity problems of the part of the United Nations organs. And the second problem, as you mentioned, is the problem of being above the law. You mentioned that somehow the organizations originally, traditionally based on the being forms of cooperation, to have a kind of a table for states to sit and to talk together. Again, in my memory, somebody once asked me, what does the United Nations bring to the table? And kind of my answer was, well, the table. It's a forum where we all sit together and we discuss. The table is the United Nations, and the states come and they can decide whatever they want to decide. But generally, long term, they make the organization having its own identity outside. Again, as you said, the will of its own. The organization should have a personality, it should have an entity which acts on its own and take accountability for acting on its own. And then, as you pointed, international organizations should not be above the law. They should follow the obligations which are historical and customary. They cannot act outside the law. But because of the immunity provision, very often they try to hide behind that immunity. And, well, not always, by the way. We have a good amount of acknowledgement of the account. Even you mentioned Haiti cholera case, but there was a realization that the United Nations should pay the compensation. They cannot really let people die for mismanagement of its own operation. And that applies also to situations of sexual violence committed by United Nations peacekeeping operations and so on. So the United Nations itself developed a kind of an internal mechanism of accountability so that those examples of cholera spread or sexual violence doesn't damage otherwise the humanitarian operation of the United Nations. So these are my comments. Excellent. I learn a lot. I'm very happy to stay until the end, although I have something coming soon. But I will ask Ankit now to moderate the rest of the question. But I will be listening, and I will be, if necessary, joining you and talking you again.
So if I may add, sir.
Yes, please.
Yes, Professor. Yes, sir. Thank you, sir. Professor Kristina, there's one question which, from your initial lecture about international civil service. So I just wanted to understand from the students as well as young professionals' perspective as to what kind of a structure exists for this kind of a service, and how does one pursue such an goal or aim? So, like, where does one start for that?
Sure. So when it comes to pursuing a career in the international civil service, different organizations have different methods. Many of them have specific young professionals programs to bring in young people through the organization. And it's a multi-step process. Each individual organization is probably the best source of information for how to embark on that process. There's often an examination that is a part of it in order to evaluate candidates across a level playing field. So this is one route. Into especially the UN system. The world of international organizations is broad, though, right? And sometimes there are opportunities and maybe more dynamic opportunities and quicker opportunity to advance and to grow by starting with a newer, smaller regional organization, right? So for example, the Asian Infrastructure Investment Bank was started up quite recently in Beijing, right? They were created from the ground up in Beijing, and many of the staff came from other multilateral development banks. And I think part of what attracted them there was the opportunity to build something new, right? And to perhaps climb the professional ladder in a way that may have been more difficult in the bigger established organizations. So there are multiple routes when it comes to things like internships and other opportunities, right, to get in early on in one's career. Certainly, the UN system organizations have made efforts recently to make that process more transparent and to make it possible, right, for people from a wider array of backgrounds to learn how to apply to follow through on that process.
Actually, I'll be in touch with you with that, because Professor Popovski's center, UN center, we try to organize certain sessions for UN careers as well. And as young professionals ourselves also look into try to find out. So I'll take your email ID from Ankit and we'll be in touch with you regarding the same.
Sure.
Thank you.
Well, I just wanted to add a small point there. There was a recent General Assembly resolution which now allows developing states also to send fellows for the fellowship at the World Court. This is a new development. Earlier it was only universities like yours who could send, but now this is opened up. I have three reflections, and I'll start from the one which was made first, is with the use of China and its international organizations. I was hearing Professor Neil Ferguson of Stanford University, of the Hoover Institute, and he is a historian, and he sort of represents that a view from international affairs, and he says that if you have to sum up China's foreign diplomacy or foreign policy, it's how to lose friends 101. And he says that in the context of how China is expanding, especially in the context of a global pandemic, and how it was making very advanced features and moves into India as well, and then also into the Indian Ocean. But I agree with the point which you made, which is that it's also using international organizations to work in its favor. I invested this past summer studying cultural and heritage law. So UNESCO was an important ingredient over there, and how China's made advancements. And upon my research, I found a lot of articles which were written about China's sort of cultural heritage and those aspects. They were quite approving of China's measures, China's steps, and not only on land but also in the underwater cultural heritage sphere, and how advanced China is in protecting and adopting such measures. So I found that quite interesting. The other point which I was quite approving and also interested about was the observer status to international organizations in bigger international organizations. So, so like the EU sitting in the General Assembly or the Security Council, I quite like that idea, and that's something that I've been thinking about quite a lot in this lecture series. This sort of seems like, to me, if I have to sort of classify this, I would think of this as regional internationalism, which is that these regional blocs sort of represent a collective voice in these organizations. Uh, but the devil's in the detail here, in the sense that you can't have this as a blanket understanding for all negotiations. This is what a lot of persons who I've shared this idea with say, and that's completely fine with me. But having these organizations as opposed to countries as such representing makes a lot of sense to me, because then the organization comes, so let's say ASEAN comes to Glasgow as opposed to 7 different countries. ASEAN represents the perspective of the countries, and then there's an ASEAN forum which sort of disseminates the information, and then each country adopts measures to its own will, and then you have the systems like the NDCs which work, which seems quite wonderful to me again. So this, I'd like your thoughts on this. And the other point which I just wanted to raise is with respect to international organizations and the tussle which takes place in the domestic system with respect to immunity, because then immunity becomes an important feature of this. We had Monica Fiera Tinta, who was speaking on exactly this, and she referred to American case laws wherein immunity was given to the World Bank, which was involved in an Indian case. In a power plant based in Gujarat. So I found that also quite interesting. And the last point is what Professor Popovski and you both sort of highlighted, is with respect to sexual harassment cases which happen in these peacekeeping forces and how immunity is used. I'd written a short note on this as well, and I was directed to Prince Zaid's report on this, which I found quite fascinating. But what happens about these organizations which are not directly involved in something but play an instrumental role on the contours, such as like a university which frames your thoughts and perceptions? So I'm quite curious then. I mean, he said that there's sort of this deadlock which remains, and what I wouldn't understand is, so does the organization then reinforce the purposes and missions of the UN or the organization, or that it works in the favor of the Japanese stance in the UN and reinforces and echoes that, or does it completely retaliate everything that it's doing, which would seem rather difficult to do, since your purse might be shrunken dramatically. And in the face of this, I close with this, in the face of populism, how do these organizations maintain this unity? Then would this regional format be more appreciated, because then the organization comes as a collective? So I just wanted to share these.
Okay. I will let Kristina answer the rest, and I will take another minute to explain the United Nations University in Tokyo. Go ahead, Kristina.
Great. So thank you for these. Thank you for these comments, and let me say a couple of different things in response. So on your point about the international civil service and thinking about how China is engaging with international organizations, so I think the trend that you observed at UNESCO, that China is becoming more active is a trend that's really visible across the board. And it is quite striking to me that two of the organizations that, right, the Shanghai Cooperation Organization and the Asian Infrastructure Investment Bank, clearly organizations in which China played a leading role in establishing, they look like traditional international organizations along important dimensions, although, and this is coming back to the international civil service, and as you also observed, the details matter. And it was notable to me in reviewing the charter of the Shanghai Cooperation Organization, how some of the provisions that address the protections for the international civil service are ratcheted down, and how there's a little bit more control over the international civil service. So whereas the language you cited from the UN Charter says, you know, international civil servants shall not seek instructions, shall not receive instructions from national governments, the comparable language in the Charter of the Shanghai Cooperation Organization is should, right? So we have weaker language when it comes to, as a practical matter, maintaining the independence of the international civil service. One of the questions that was discussed at the negotiations of the UN Charter and was revived in the early history of the UN was the question of whether member states should have an explicit role in selecting, you know, the just below the top tier of officials at the UN. And Dag Hammarskjöld, as the second Secretary General of the UN, insisted, no, right? These are decisions, sure, they're going to be influenced by the views of member states, but ultimately it's got to be for the Secretary General to select his or her own deputies. If you look at the Shanghai Cooperation Organization, there is, right, this idea that was rejected in the context of the UN gets revived, and there is a role for member states in picking the second tier of officials. So there are ways in which protections for international civil servants might be dialed up there or might be dialed down. And there is definitely variation there across institutions. When it comes to observer status, I think there's some really interesting trends, and I'm working on a project now that is really trying to get a handle on the full universe of charters of international organizations to better understand the ways that they vary and the ways that they are similar. But one of the trends we've seen in our preliminary analysis that very much coincides with the argument that I'm making in this lecture about the importance of IO to IO interactions, including through observer status, is that over time, charters have been increasingly likely to include provisions that expressly address the possibility of other organizations being observers at the new organization, and the new organization itself being an observer at other organizations, right? Provisions that directly address the capacity of the organization to enter into treaties with other organizations are more common, right? So as new organizations are entering this more crowded international space, the founders are deliberately making plans for how that organization is going to interact with other pre-existing organizations that are already on the scene. This question of how regional and universal organizations interact is an interesting one, and it's actually, right, if you look at the establishment of the League and the UN, this question of how to integrate the regional and the universal organizations has been a persistent challenge, and the answers have shifted over time. And of course, one challenge is that the regional organizations vary quite a bit among one another, right? So it's a little bit difficult to have a completely uniform, universal to regional structure given how much variation there is among the regional organizations. The World Health Organization is an interesting case study for this as well, because compared to the other UN system organizations, the World Health Organization was created on top of a pre-existing structure of some regional organizations. And the regions in the WHO still have quite a bit more autonomy than they do at other organizations. And that comes with both advantages and disadvantages, right? And among the disadvantages are that it's much more difficult for the WHO to be a coherent organization when the regions are so powerful, right? It necessarily weakens the center organization. And again, in ways that may have some desirable consequences, but I think they are complicated. On this issue of immunity, and I want to come back to the point of internal processes, right? So I think the development of some internal processes is a very positive development. I think internal processes within an organization are far preferable to lawsuits going forward in national courts. But so far, the internal processes are not as comprehensive as they ought to be. And I think the outcomes still often fall short. So it's true, as Professor Popovski noted, that in the context of the UN, the Secretary General eventually apologized and there were plans made for compensation, but the actual very little money has actually come through, right? And here the funding piece resurfaces again as a key issue, because the compensation for Haiti was not funded through the UN's regular budget, right? It was a voluntary trust fund, and it's been a little while since I've looked at those numbers, but the last time I checked, less than 10% of the planned funds had actually been collected by the UN. And in a situation like that, it still remains quite unsatisfying, in my view. So I think there are real questions about what an ideal design for internal structures look like. I think the question of the right kind of remedy is often going to be a difficult one. I am not sure that compensation is always going to be the right approach. I think that an honest accounting and apologies, right, and serious efforts to both acknowledge what went wrong and to commit to avoiding similar problems in the future is at least as important as compensation in many of these cases, right? So I'm thinking of an approach that maybe draws more on alternative justice mechanisms. So I think there has been progress. There has been progress over the last 20 years in particular along this front, but I think there's still quite a long way to go.
Thank you, Kristina. It's really very, very interesting. In a way, the United Nations is a global organization which kind of has a multicultural essence in itself, but obviously in a particular situation, it may get into a bit of a, let's say, tension with some domestic roles. I have two anecdotes in my life in Tokyo with the United Nations University. And one was that under the United Nations rule, everybody needs to retire at the age of 60. And that is a rule probably going back 70 years ago when the lifespan was about 60, 65. But you know, in Japan today, the lifespan is for female, particularly is probably 90. And when a Japanese lady at the age of 60 had to retire because the United Nations say so, for us as managers, it was pretty much unfortunate that we have to retire the best working in my team because just of the age of 60. where in Japan she could have easily worked until the age of 90. We figured it out. We offered them consultancy contracts after the official retirement with the United Nations. We simply refigure out how to do that. And in another example, I was also remembering in Japan how a person whose contract was not extended improperly by the administration in that case, they didn't give the 3 months notice, and acting as a part of the staff council, I went to the management and the rector and I said, no, you should pay the 3 months compensation because you didn't file in writing the notice. The administration said, well, when we extended the last time this contract, it was 6 months extension. We made clear this is final and not renewable. But I was kind of legally sticking to the written rule, fighting for that lady and saying, well, 6 months ago is 6 months ago, but the letter of the agreement says 3 months written notice, you should pay the compensation. The administration ended up by saying, well, we don't want to put it as a compensation, just not to create a precedent, but we will extend the contract for 3 months. The lady doesn't need to come to work, but she will get the 3 salaries. I was so happy with that. And I went to the lady and I said, look, I fought for you. I went 4 times to fight for your rights with the administration. Please accept that deal. You get your 3 months salary from now on, but you don't need to go to work because they probably hire somebody else already. And she refused to do that. In Japan, you cannot take a salary if you do not work. Maybe in every country else you can. In my country, it would have been easier for somebody just to receive a salary for 3 months, but not in Japan. Again, a cultural clash between what the international organization may think that's possible and not knowing what the sensitivities in the local space you are operating with may bring some sort of disconnections, let's put it this way. I would like to see some students asking questions as well. So Ankit, do you see any? Let's encourage some of the students also to speak.
But I hope you were compensated handsomely for your advocacy.
Okay, thank you, Ankit. How much time do we have yet? Let's see.
So,
It's almost 6:30.
So it's 6:30 on the dot. I don't see questions, so I think we can close.
Thank you, Kristina. It was wonderful. We hope to see you on campus one day in India. We really admire your expertise, being part of various jobs, and quite interesting for us to learn more from your legal practice and from your work for the United Nations as well.
Well, thank you so much for the invitation. This was a real pleasure. I enjoyed our conversation in particular afterwards. And I look forward to staying in touch.
Thank you. Thank you so much, Professor Kristina. Thank you, Professor Popovski.
Thank you. Thank you, Professor. I'll be mailing you shortly with few details for a few other future assignments. Thank you. Thank you so much.
Thank you. Bye-bye.